Hello. Yeah. Good afternoon, friends. I think we are just waiting for people to finish the desserts. Maybe we can wait for maybe a minute or two. But in the meantime, let me give a little basic framework where we are, and maybe when I see few people coming in, I'll also introduce the speakers. But the whole idea of today's session came about at the Inter-Pacific Bar Association meeting, and this is the International Construction Projects Committee at the IPBA. And the discussion in one of the meetings that we hold every few weeks was that obviously everyone acknowledges the fact that India is going through a huge infrastructure development. The need of infrastructure, real estate, and construction development in India is, I don't think there is any debate. There are, reports after reports which talks about that India, construction industry in India is going to reach almost $1.4 trillion as by 2025. So we are not far away. It's just a year from now, we will be like, construction industry in itself would be a $1.4 trillion industry. It obviously touches sectors across, and in one of the reports from Invest India, it talks about that it works across almost 250 subsectors which are linked to the construction industry. So its tentacles are in that sense touching many other industries. So this 1.4 trillion is just the one side of it, but many other industries which touch larger infrastructure, real estate, and construction industry is even bigger. The expected contribution of construction industry, again by one of the reports in India, says that by 2025 it would be almost 15% of the total GDP. So which is again a very big number, and at least we don't have the latest data, but in the financial year of 2021-2022, the India's construction sector attracted FDI inflow of more than $35 billion. So you can understand the magnitude of this industry in that sense. And every time, at least when I attend some of these committee meetings, they talk at a level, where we say, look, none of this exists in India. They are now talking about how FIDIC contracts can be more regionalized, how things can be more streamlined. They are moving from dispute adjudication boards to mediation to even specialized courts and specialized laws in each country. And when they hear the story of India, they say, look, there is obviously a lot of resistance and things are very different in India at a very basic level. On the other hand, we keep hearing that every year, forget different parts of the construction infrastructure industry, just the NHAI disputes are in the range of 40,000-50,000 crores, and then they settle at less than 25% of that amount through different schemes and things like that. So the magnitude, the numbers don't corroborate to the kind of efficiency we require in both managing the contracts and thereafter obviously the something that you cannot avoid or unavoidable issues related to disputes. So that was the context in which this session discussion came up, and then I suggested, why don't we do it during the ADR week, because that's the right forum. So that's the broad context, and we got a stellar panel to talk about it. I won't go into the detailed CVs of each one of them, but to my extreme left is Anand Srivastava. He is a managing partner at one of the largest and most successful law firms in India, Denton Snink Legal, and primarily looks at infrastructure and aviation, having global, experience and also studied outside India with, several scholarships. Then we have Ruchika Nayyar. She is part of a group called Nexus Malls. It's a Blackstone supported entity, and they are looking at several new ways of looking at malls and other infrastructure as part of that portfolio, including REITs, and she is the general counsel at Nexus Malls. Then we have Naresh Thacker. Again, he's one of the most senior practitioner in this industry, including at Economic Law Practices, which is another very, very prominent law firm based out of India, having multiple offices across India. And then, of course, one of the stalwarts, Amit Kapur, is a managing partner at JSA, again looking at many different subsectors and sectors around infrastructure, including a lot of regulatory issues in that space. So without going into too much of detail, I'm sure some of you know them personally as well. So what we thought that we will look at this whole discussion in two or three different parts, and straight away getting into the first part of it, where we want to first understand the broadly the Indian construction sector and its relevance to the growth of Indian economy, and then how the law and the regulatory landscape has evolved in maybe last 30-40 years. While we don't have a specific construction law, we don't have specific provisions around how to interpret construction contracts and things like that, we still fall back on Contract Act and Specific Relief Act, unlike many other jurisdictions. But that is one major part that we wanted to look at it from the progression, how it happened. So may I go straight to Amit on this, and maybe if you can give us a broad overview of last 3-4 decades, and where we are heading in next couple of decades as we see.
Thank you. Pleasure being with you. I hope we'll keep you awake in the afternoon. We have some very good luminaries on my left side, so I hope they will keep you engaged as well. I think infrastructure, without a doubt, is a very critical growth engine for India today. Vyapak mentioned $1.4 trillion is the projected investment for the 5 years. Only 25 to 27% is expected from the private sector. The question is why? And the reason is that we have still a huge hurdle on enforcement of contracts. And I have a bone to pick for the place that I belong to, dispute resolution, particularly arbitration. Most jurisprudence that has come up in the law of contract in the last 15 years has been kept closeted in awards, and we have not been able to evolve. So there's a straight question to Niti and her colleagues. Why are they not able to evolve a mechanism where which, while keeping confidentiality of the matter, at least the ratio and the jurisprudence is out there to cite, other than an odd case where the same clause into arbitration panels.
Amit proposes and Niti implements it right away. So just Mundi, they just signed an MOU. Sorry to
Very
interrupt.
good.
You are going to see redacted awards of MCIA
Delightful.
in 2024.
Well done.
Sorry to interrupt.
No, we are on a song then. There we go. All right, so I'll move on my next wish list. That's very good. I can ask for a few things today.
Looks like today, if this is
answered. That's right.
No, I'm saying today, if this is the kind of things happening, then better you talk about India-Pakistan match.
That'd be the last
what you want, because what you want is happening.
We got the first.
That's it. You have the golden hand.
So there are 2 or 3 things which somehow we have not been able to disseminate with as much awareness, which is very critical. And one such thing is that the law of contract, as it was getting into a position of implementability, the Kelkar committee in 2015 came up with a report to rejuvenate PPP. And in that context, fast-track dispute resolution came up. There are various mechanisms that the government has put in place. But the tragedy has been that the lament of 1985, O Chinnappa Reddy, sitting in Dunlop, India, 85-1 SCC, and the layment of Justice Gawai, 2023 in GMR Varora, is the same. Repeated challenges to already litigated disputes with courts interfering. While arbitration has largely shown the way, there are still trigger-happy opportunities where courts get into it. One such was the instance in 22 when Justice Gautam Patel in a division bench had to interfere in a matter where the same arbitration clause, two arbitral panels, conflicting views. So fortunately, we got some jurisprudence out. We finally learned that the same price escalation clause was being looked at differently by two panels, and that conflict got resolved. Matter is now in Supreme Court. Hopefully it see the light of day soon. Matter was to be listed in these months, so we'll find out. But what I'm emphasizing on is very critical for all of us who are concerned with dispute resolution to ensure that the advancement of jurisprudence does not get locked out. Absolute confidentiality must be maintained, no difficulty. But it's our duty as practitioners to bring that out, because if you're talking of $1.4 trillion investment, you're inviting investment in. We are duty bound to make sure that we don't have challenges of consistency. That's the heart of the matter. The second area where I think infrastructure has a very critical role, and I think it's vital, and I'll leave it at that, is that the issue of time value of money and the fact that infrastructure disputes are a class by themselves. Largely construction, focus on infrastructure. The Parliament has recognized both as critical components. Please bear that in mind, and please ensure that you bring it to the court or before the arbitrators every time you're there. 2018, the Specific Relief Act has been amended. There is a fast-track dispute resolution mandated by law. Injunctions must not be granted unless a very specific reason is given in the order. Disputes must be resolved within 1 year by special courts. Arbitral panels cannot drift on that for years. Because if the Parliament says that for special courts, surely the panels will also have to be encouraged to look at that. That's a duty that you and I will carry as counsel when we go before them. Because that's a parliamentary mandate now. Second, the issue that arises very critically at the stage of bidding for the contracts. Now, the dust has settled. Justice Joseph's judgment on Sasan Par, April, on the issue of disclaimers, has clearly made it evident that notwithstanding what you may feel, if it's been disclaimed by the government and it's a problem, we'll need to go back and push hard to make sure there are fairer contracts than what we see. If there's a whole-scale disclaimer on hydrology or geology of a project, where you have to construct either a highway by drilling a tunnel in the mountain or a power project, you have 1 month or 2 months to due diligence. The project takes 6 years. There is no way that you're going through 30 kilometers in the heart of the mountain to find out what is the rock classification. You don't have the hydrological data. And if it's all of that is disclaimed and you are supposed to do your diligence, that diligence is impossible. If in spite of that, you and I go ahead and work with clients and bid and take the risk, they'll have to price the risk. If they don't, law is well settled now. No question of going back for any price escalation or any change in the name of force majeure change in law. So 2-3 aspects very critical, which you and I as practitioners will have to bear in mind. The numbers are all there for us to see. But to actualize the numbers, we'll have to make sure that our environment actually attracts investment and preserves the value, both for the contractor and the developer. Because delay comes very costly in India. It comes at 12 and 14% per annum. It doesn't come at 1 and 2. And then there is compounding on top. So we need to be very mindful of that, because as practitioners, that's the heart of the matter. Risk and value are two sides of the coin that you and I play with. And we must be very vigilant. I will stop here because
Sure.
much
Thanks
more
a lot. And I think we have obviously heard the practitioner's perspective and somewhat little negative and of course some positives. But maybe if I can bring Ruchika here and particularly from a perspective of the sector and the economy and its, how the growth has contributed to the economy in general, and how do you see this growing further, and what are the aspects that you would like to see as a GC going forward?
Yeah. Hello. Yeah, thanks Vyapak, and thanks to the organizers for inviting me here. So as Amit said, infrastructure, is one of the most important aspects in growth of any economy, including India. And looking at, India looking at being a US 5 trillion economy going forward in 5 years, I think infrastructure would be paying a lot, and it should also be growing at the same pace. And as Amit said, PPP models have been there for years, where we have seen still, there being delays in the projects, the matters being stuck in litigation for years, and ultimately, it affects the, normal public only. The cost escalation is ultimately, it is passed on to the general public, and we have to bear the brunt till the, the infrastructure projects are stuck in litigation. But I think, recently government has been doing a lot in this. The government's focus has been into infrastructure, as the National Infrastructure Pipeline and Plan had been launched recently, where the government is looking at putting in, a lot of money into the infrastructure projects by way of various fundings. And also, I think the National Infrastructure Bank, which is to be incorporated, where they will look at innovative methods of financing for infrastructure projects, where, obviously it is a long-term funding. So bank funding, we see that there's always an asset liability mismatch, and, we are stuck with banks. So therefore, bond markets need to be developed where long-term financing can be done, and also innovative methods of funding, maybe derivatives can be brought in, and also the insurance sector and pension funds, where they can bring in money for long-term basis. I think that would give a lot of boost to the infrastructure sector.
Sure. No, thanks a lot, Ruchika. And if I go a little further to Naresh here. So Naresh, I think we all know that this is a, in a way, it's huge monster to, deal with. And the world has dealt with it in a certain fashion, where the contractual lay of land is very clear, it's very succinct, it's standard templates, FIDIC contracts, NEP contracts in UK, and there are many, many such examples. But India has taken a little different path. It's little ad hoc, sometimes it's very diluted standard form contracts, and therefore it becomes even more confusing and complex when it goes to interpretation and disputes. So one, if you can give us an idea why India is not taking the same path, which not that we have to, but then what is the alternative and where we should go? I think idea of this discussion is from a future perspective, what's the best way forward, taking care of India needs.
Thank you, Vyapak. So, let me begin by saying that we do have standard form contracts which are not so standard. That's the starting point of everything. We talk about standard form contracts. So you would typically, if you look at any, largely as what Amit has already laid the, lay out the land for all of us. If you look at 1.4 trillion, only 25% is private sector. Clearly, everything is public sector undertaking. And when you look at public sector undertaking, one thing which comes through very, very clearly is that despite all of these companies that you see being, whatever Navratnas that you talk about, or any other public sector undertaking that you can think of, these are what? These are ultimately government undertakings. Despite the fact that these are government undertakings, if you pick up contract of an NHAI versus an ONGC, the stark difference that you will see in the standardization is something that, as a lawyer, when on the opposite side, when you're arguing a matter, you come across, and it at times is horrific, when you're dealing with these contracts. So, what does everyone do? Each government enterprise will have its own sort of a standard form contract. The starting point could be a FIDIC, for all I know, but everything of the GCC that is, not in the favor of the employer becomes a PCC, where everything, all the burden is shifted, all the obligations are shifted to the contractor. Now, is that the best way to go forward? Naturally, no, I don't think, that's the best way, because 2 or 3 things happen in that. If you are going to do what you are going to do, namely, let me pick up something as simple as the scope of the contract. You pick up any contract, be it railways or roads or bridges, what you'll find is that, and if you were to look at the scope is so widely defined that you truly do not know, what all is encompassed in that contract that you're dealing with. While the same contract will also provide for a change order. What are you then fighting for at the end of the day is that, the question that usually people are fighting over is that the contractor says, this part of the contract that you asked me to do was actually a change order. And the employer would say, but you look at the scope. In the scope, everything is written. The words used are what was necessary for the project, what is necessary for the safety of the project. And that I'm facing such an issue right now where, the other side is arguing to say that, oh, but, this was necessary for the safety of the railways. And if it is necessary for the safety of the railways, you had to provide it. Therefore, in the catch-all provision of the contract, this is already covered. And I'm arguing to say, but this, how could you use a catch-all phrase in the contract or a catch-all clause in the contract to ask me to do something which was entirely different? Entirely different. It has nothing to do with, what otherwise I would have been able to do within this contract. But there you are, I'm facing this kind of a situation. So therefore, clearly, it all is lopsided. There is no uniformity that you find. The approach obviously is to, protect as much of the employer as they can. Insofar as, even something as simple as the payment part of it, you have running bills, and I think Amit and I were talking the other day when all of us were having a chat, and, we are thinking about, how to bring this out. But look at the payment terms in a FIDIC contract vis-a-vis what you would have in a contract that you would typically see at any of these public sector undertakings. In a FIDIC contract, we all know that if the contractor remains unpaid for a given point in time, he can seek suspension of the contract. In fact, he gives a notice to suspend the contract. Now, dare any private player in India seek to suspend the contract? The first thing that will happen is, and despite the fact that he remains unpaid, there are cash flow issues, so much so that, he can possibly go bankrupt if he's not paid. But can he give a notice of suspension? The answer would be a straight off no. Why? Because every contract that you see, a public sector undertaking contract, will have clauses on blacklisting.
Yeah.
So this contract you may fight with the government, the next contract you are blacklisted, so you're not even out there, as a player in the market. So, these are the sort of issues that we, continue to grapple with, and this is something which has continued from the time immemorial, I would say, and up until now. And as Amit rightly put it, even in 2023, there is a lament by the Supreme Court that, nothing has truly changed. What ought to change and what ought to happen is that time has come. We are now at a stage where like I was again saying, there are two things which OECD pointed out just a couple of weeks back, two gaps. In where the economy and how the economy is progressing. One was infrastructure, the other was logistics. Clearly, both are interrelated. Clearly, these are both necessary for the purposes of India to grow, to become the kind of economy that it hopes to become. $5 trillion economy will not happen on the back of, just some services and manufacturing. Yes, you need services and manufacturing, but let's say you manufacture goods, and if you're not able to evacuate those goods, what are you going to do with those goods? Where are you going to store? So you will need equal amount of warehouses, you will need equal amount of manufacturing units, but equally you will need the roads, the railways, everything to come up.
Sure.
So time is ripe when we should move towards true standard form contracts, namely the FIDIC, the NEC, pick what you like. You can, and again, you're right, Vyapak, when you said that, it need not necessarily, we need not ape anyone. This is not about aping anyone. Pick a contract that you believe is right for you, and then learn to live with it. Don't tinker with it to an extent where everything becomes irrelevant in that so-called standard form contract.
So, so moving little further down there, and maybe I'll bring Anand here, because at one end, the regulatory and legal landscape we have heard from Amit, we still don't have the standard form the way predictability and consistency is required in the infrastructure sector. So when it comes to infrastructure projects or development projects broadly, and more importantly, it's management of those contracts, right? Uh, can we do something there? In sense, are there precedents? From your experience, Anand, has any specific subsector implemented some management principles of those contracts, which at least addresses some of these concerns, or maybe what's your take? How we should do it?
Thanks, Vyapak. Thanks for having us all here. I think personally, what I am seeing now is that construction contracts are becoming a smaller piece, and we are seeing, as you rightly said, infrastructure projects as a larger, play where we have all the stakeholders buy into the same arrangement. We have the lenders come in with the substitution piece. We have the design elements being drafted into the contract. And as, Amit sir pointed out, disclaimers, the site conditions are disclaimed. We were discussing subsurface and surface in the morning today. And also what we are seeing is that, the land and property acquisition of, let's say even a high-speed rail is landing itself in trouble. And basically when the investor or the developer comes in, he comes with 70% of this investment being backed by lenders. And the lenders therefore are also now a stakeholder. It's not a matter of only FIDIC alone, because the construction piece comes as a smaller segment of a large, interplay of several things coming together. And these contracts therefore, have to interplay much, intensely. Just look at the new, our whole wish list of, bringing high-speed rail into the country and making wagon manufacturing into our country, right? The bid has 3 large contracts which do not kind of, get into a plant and machinery procurement standard JCT template. It is so far away from that, because the government is also, imagining new ways of financing such transactions. JBIC is, of course, funding the entire high-speed rail, and therefore the Japanese conditions are coming in, and that's a big, The other thing that our FIDIC doesn't answer is, for example, we were discussing the dispute adjudication board.
I know, I was going to.
It talks of a notice of dissatisfaction being given. But then we have had instances where one party gave a notice of dissatisfaction but did not initiate arbitration, and everybody was in a lurch now what to do. So what I think even the government needs to know is that the Contract Act itself makes a saving for, in Section 1 for incident of contract. And whatever clauses you draft cannot go in the face of, Section 51 to 55, which provide that if you are in default, you cannot deny compensation, especially where time is not of the essence, right? And 54 especially provides that if, Section 54 of our Contract Act provides that if there is a sequence of activities assigned to each other, then if one party doesn't perform that part, the other party will not perform its part, and it's entitled to compensation.
He gets the advantage.
And 55 provides that, if you, of course, time is of the essence and you maintain time as the essence, but then if you then, accept the performance or the late performance of one party, then, you have to do it by giving notice of your intention not to be bound by it. And then you can claim these exclusion clauses.
Sure.
And on the improvement part, of course, our contracts today also do not provide for the distinction between delay and disruption, which, Amit sir and Naresh and you must be arguing every day in arbitrations. But delay, disruption, overheads, and, loss of profits are also then, not kind of written down well in our contracts. And FIDIC somehow assumes that, the Indian market would be wise enough to pick them up and, be able to kind of maintain its records according to that.
Sure.
Disruption, obviously, I'm sure, for everybody, disruption and delay is different. Disruption is basically when something underperforms and causes, accumulation of losses over a period of time. And there, of course, we do the critical path analysis. Our contracts do not provide for any analysis on delay. They do not provide for the standard MDEN or, Hudson formula or, the formulas, etc. are all available today. we need to choose what we are trying to kind of
implement.
write down. Contract principles of concurrent delays or sequential delays are not written.
Written on.
Do you want me to take the question of improvement now or later?
Yeah, maybe you can just
Okay,
quickly
so
touch
quickly,
upon it.
Of course, one important point where our contracts remain silent is whether program is a part of the contract, which is the contractor's wish, and program is not a part of the contract, which is the employer's wish. Normally what happens is, if you were to draft a harmonious contract, you would have more like an alliance where the program records on a moving basis what we call the time scale, model of, it's called the line slice model of programming, where you kind of ensure that, you have a real-time program which incorporates all the events of all the stakeholders, whether it is the authority, the local authority, the lenders delaying, disbursements, or, ground conditions, as Amit sir was pointing out. And the program becomes more live, and, everybody kind of works to that. But that doesn't happen. Mostly our contracts, as Naresh was pointing out, are employer friendly and program is kept out. The float or the extra time that is provided in the program is left to the contractor to manage. And that becomes a big risk. So therefore, what we can do is ensure that, in our contracts, we provide for record keeping. So the golden triangle, which is basically, which proves the cause and effect of any, keep the meetings of the site, the employer, the contractor, the lenders, engineer. Inside the day worksheets, for example, are important tools for our disputes and, accelerating them. Keep the SCOT schedules going from the beginning. I think the sites, the contracts managers should provide for SCOT schedules right from the beginning. We need to have provisions where we appoint the DRB early, or the dispute avoidance board, whatever you want to call it. They are extremely helpful. In fact, we had Dr. Fletcher in the afternoon today, and the London Olympics happened because the DAB had 17-member panel, which was formed to ensure that the London city was able to do everything on time for the Olympics, and it's one of the largest projects which was ever done. And lastly, the contracts need to provide for early warnings rather than claim costs later. So one very smart thing that contracts also provide nowadays, NEC is a very good model. Very few people understand it, but NEC gives the comfort. It's light years ahead of FIDIC in a positive contract environment, especially from the early warnings principles.
Correct.
So I think that would be.
So I think obviously all of this is available while we are still far from using some of these methods.
So one more, interface management. Site allocation, how people move around, I think that's also to be provided in the program itself.
So, I'll just, two very quick examples if I can give from what, Anand has spoken. One is obviously of the interface management, but before I go there, another example that I must give of a recent matter where, we were discussing issues around land being, handed over. So what happened was that, we were in a railways project, and we were, obviously railways project is in the sense that one understands it's not a linear project. I mean, it can never be linear, whether road or railways can never be linear. It always goes through, a mountain or a valley, and therefore there are various issues that are required to be dealt with. Now we were told that, okay, we've handed over land to you. So what typically would happen was, they would pick land, they would give us, let's say 600 meters of land, then a kilometer of land is not available. Thereafter another kilometer is available, 5 kilometers not available. So as contractors we said it's impossible to build. How can you, this is one, not linear. Two, how do you expect me to align? There is no alignment. I need to make the alignment, and I can't have the alignment if I do not have contiguous parcel of land. I'm not telling you that, you have to give me the entire 45-50 kilometer of land that you are supposed to give me at one go, but at least give me sufficient workspace. That was the whole ask. Well, it never happened. The contract, went on, and then at the end of the day, we obviously put in our claim, and when we put in our claim, this was really the argument which was given. And they have, and I don't know how, but they have an expert up there saying that, oh, but you had the parcel of land, the 600 meters was available, you had another kilometer over there, why couldn't you, build? And then it was all a matter of joining the pieces together. So this is not Lego land that we are playing, this is live contracting that happens.
Happening.
Which happens. The other issue which arose in the same contract was that, obviously if we are making this railway line, there are high tension wires which are, they obviously need to be relocated. From a safety perspective, even while we are working, you need to relocate that. This high tension wire had nothing to do with us. It was not even a part, in that sense, a scope of the contract as we were, as we read it. But, there were other agencies at work in and around, that path. And so the interface issue came up over there, and the clause, which was up there was read and said, oh, but interface, you are the contractor, you were the main contractor. It said something like that the main contractor will take care, we will provide you all the help, we will facilitate. So he said, you must be joking to think that, as the main contractor in the entire 45 kilometers, I would be able to predict. And importantly, the 2-month period that Amit spoke about, that was about the time that we had to, look at the surface and the subsurface area. Without the land being made available to us, we were told that even the subsurface is your responsibility, and the disclaimer was given. Now, in those situations when you're working and you're arguing, and this is where, another issue comes to the fore, that you are before a tribunal, maybe of retired judges, and they aren't able to understand what you are asking for. Because when you tell them it is impossible to have the alignment made the way they are asking it to be done, that you cannot have, these broken pieces of land parcel being
Coming
given.
together.
How do you, and it becomes, and so you start realizing a lot of things. It is not just, these issues within the contract. It's also about the fact, and rightly, as Anand has put it, there is no dispute avoidance methodology which is provided. Even if it is provided, it is redundant. People don't utilize it. It is only meant for, as we understand in India, time pass. Beyond that, nothing else. Everything is left to the end of the contract for in an arbitration. And the arbitration, there aren't people who are manning, the arbitration who understand what we are talking about.
We have obviously seen the problems because of that, right? I think in 2019 or something, if I remember the numbers, some more than 200 cases and sub 75,000 crore disputes against NHI. I don't know what's the situation today. And DAB is not working, the contract management is not happening. So maybe Ruchika, from your perspective, you are the industry. We can enjoy this session for days together. But do you think now with the mediation, and even internationally there is a lot of discussion around mediation in construction contracts, particularly, of course, it goes through the progression of DAB and other mechanisms, but from an industry ask to deal with some of these issues, what's your take on it, right? Because ultimately we need to resolve these disputes.
Yeah, sure. I think, mediation as a process and defining it is fine, but the issue is the intention. Even though it's an informal way of resolving, rather, people think that it is like, you have some person has to win or lose. But what I feel is it's a resolution where a third party is, basically a neutral person who is deciding for you. But then, because it's not a formalized thing, people, even though they may agree in a mediation, a particular thing, but they can go back because there is no, sanctity to do it. And ultimately, it leads to an arbitration. So, the basic is that what is the intent of the party? If they seriously want to avoid, long-run litigation, I understand that mediation can be a very good means of resolving, provided that people have intention and they stick to what has been decided and what has been agreed under the mediation process.
No, I think government is obviously trying its own ways. Ministry of Finance came with Vivat to Vishwas 1 and then 2, and I don't know how many versions would come. And then NHI came up with Sarod, and there are other suggestions also. So maybe if I can bring Amit with his experience and expertise on all of this. Do you
So
think this is working? Do you think we need something else?
So I
And
think
what is that something else? I think we all know the problem.
what's working is the last 2 points made, because Pakistan lost 2 wickets in the last 2 runs. But what can work even better if and here's the second wish list, is Niti's run away, is it? Niti's run out. Anyway, I'll put it to you. Yeah, there. Well, Lokesh is there. Why don't we consider MCIA, IPBA having come together, so many of us around, coming out with a best practice guide on risk allocation and mitigation, compare FIDIC with NEC with the 3 or 4 key Indian models. Because unless government will come with their models as they feel appropriate. So when you had 75,000 crores plus, I worked on that committee, worked with the CII, took it back to the government. What did we get? They said against arbitral awards, we'll release 75% of the money, but you'll give a bank guarantee for it. So here I am getting the money that I am entitled to, and now I'm paying margin money for that money too. Nobody took it. It was just eyewash. So it doesn't work. Unless from the industry we come together and bring out, as practitioners, you forget the industry for the moment. I understand there are concerns about the industry taking it up because of late it's frowned upon, if a particular. But as a body of professionals, why can't we put out there and say that these are the 5 or 7 risks which are coming in the way? And unless you are able to tackle it, it'll remain a pipe dream. It'll be on the books. You will continue with 20-25% private sector. And the investments will not come through. Because India is, I believe, and this government is quite determined, to move forward. And we have made forays. Whether you look at the judgment in energy watchdog case, where we are the only common law jurisdiction in the world, where change in law now, which is expropriation in another word, is a ground for restitution. It's settled, people have got compensated, things are done and dusted. Every time the regulator or the state authority has been reluctant, they've been wrapped on the knuckles. Whether it was Indira Banerjee in MSCDCL, whether it was GMR with Gawai, it was Sanjay Kaul pulling up, or it was Rajasthan. So various states, ultimately the money got paid when the chief secretary was named in a contempt petition, and the Supreme Court said, if you don't cough up by 31st March, please come here, we'll send you home. Money came.
But it
Unfortunately, we don't need to go that far.
Yeah,
it is not necessary. So all I'm saying is that rather than wait for those instances, if we could come up with some suggestions. After all, Kelkar committee took that forward, the amendment came.
Sure.
There may be a reason for us to look at more positive, constructive suggestions, like the ones that Anand and all the other colleagues, Naresh and Ruchika offered. And I think there is a reason for us to move forward. So if you look at the model that we followed, and energy watchdog is one classic case where I was deeply involved, and the problem was that you had every possible public interest issue and political economy issue against you. 4.5 years, the compensation came through. But the other side, which is a very sad lemon, 1995, I still remember, Nathpa Jhakri hydroelectric project. The government chose the site for constructing a coffer dam to divert water from river Satluj to build a dam and to tunnel 30 kilometers in the mountain. Gave you the 2 months. By the time the contractors came to the site, the left bank of the mountain had collapsed. The rubble in the river was higher than the dam that was built. Indian Navy had to take 18 months. Contractors were liable for paying 3 crores a day of delay. No liability on the grantor. Did anybody even bother to think what was the loss to the country for 1,500 megawatts of electricity being denied for 3 or 4 years? No. Can we go back and say that you have to be a fairer proposition, have something there which is going to bite and solve for both sides, so that there is expediency? On top, 30 to 40% of every bill was retained. So from a contractor, you suddenly became a financier and equity holder without having any equity. Now that's a hell of a baggage to carry on your shoulders.
Sure.
So that 75,000 crores comes in the way of anything else. Your flip on contracts on TOT is a reality all of us know. So all I'm suggesting is that we all know the problems, we also perhaps have ideas of solutions. Can we put it out to them as MCI and IPBA, and why not?
Sure.
I'm happy to volunteer if the forum takes it.
Yeah, I think that's a great suggestion. Maybe we'll follow up with you on that.
Absolutely.
But Anand, if you have any thoughts on, with all the issues related to right from law to contracts to contract management, but with all this happening in terms of managing disputes, I don't know if Naresh or Anand, you want to add a couple
So
of
you'll talk
lines.
about capacity, because that's the biggest problem. We sign contracts and forget about it.
No, I think one model which has worked at least in one project in Tamil Nadu is alliancing, where the risk and reward is shared equally amongst all the stakeholders. And Tata Housing did that project in record time.
Okay.
Alliance contracts are contracts where, everybody puts their reward at stake and forms a committee which is common, and they work through the project together, mitigating all the assets. And all the liabilities are, as I said, early warning systems are there, and they, imagine it. Because in the end, the lender's interest is the most, significant. While the government is granting, the land or, the ambition to construct, it is the lenders whose money is playing, and it is in the end public money.
Sure.
Whether it is coming from Japan as a loan or it is coming from our own banks.
Sure.
And therefore the lenders need to have a bigger say as we kind of move forward. Because it is very late in the day when the lenders are called to the party. It's either a suspension or a termination scenario when they first come to know that, the project is
going through troubles.
Is going through troubles.
Yeah.
Cost overrun guarantees are normally funded by entirely the developer or the contractor, as you like it, and the project cost is taken as the least of three. All these things basically make any project very, very risky, and mostly the way I'm sure all of us know developers fund it is by inflating the costs and building
then
equity
you get into the cycle.
and building equity into the financing.
Yeah, yeah. So that's the
And
bad
that doesn't
cycle to
help.
be in.
So one of the things which we were, as Amit sir was discussing in the morning, is to kind of see that we have this concept of incomplete contracts where everybody kind of continues to work through. We can't imagine all the risks that are coming in, and therefore more like what mining contracts do, where we have a nimble or a more dynamic kind of a arrangement where we kind of keep moving the contract pieces to ensure that the ultimate objective, the end result, is where we are working towards.
Sure. So while we are talking about suggestion and comments, okay, if with all the due permission, with all the speakers, can I bring in the audience here?
May I add just one word here?
Please.
I think at the heart of infrastructure is the fact that some public asset, some public facility is made available to private sector for the purpose of developing what is for the consumption of the economy.
Yeah.
If that's true, Article 39 B and C should inform, it should be mandated by law, all decisions by all tribunals, all courts, all policymakers. Unfortunately, most decisions are made from their individual vantage point without worrying about what's the impact on the economy. And that is the problem. So that specific Relief Act amendment, it's instructional to read it. I was involved in it, so I understand
So I
it.
think
So
he
so
had a-
before,
welcome comments from
before that, if I can just take that thought forward, and there are two thoughts on which I just wanted to take this forward. We are talking about, and absolutely right, it's the lender's money which comes in, and Amit, you made the point that ultimately what is going to be built is for the nation, is for the public. In both ways, we suffer, because obviously the lender's money which is coming in, there is no funder which wants to come into India and put money in an infrastructure which is being developed, which is very unlike what happens in outside the country. Here the funder, if at all he or she is coming in, they are looking at built projects which they can take over. So everything which is being funded on account and through public money. If that is so, one of the questions that we need to ask ourselves is that is it now not the time, and this is what the government needs to ask, that every lender should have, it's like an independent director on the board of a company. Why not have, someone from, and you are interested in this, it's your money, you've lent it. There is hardly any contract management which actually happens in a contract in India. So should a lender not have a person overseeing the contract from beginning until the end, because it is ultimately public money which is stuck in it?
Sure. Yes, sir.
They did have the
You had-
independent engineer and the lender's engineer, but they are failed institutions.
They have become a failed institution.
Yeah,
Please.
So, picking up the thread from where Amit left it, one of the that suggestion of really doing a kind of a paper or a research study, one of the pointers could be really coming out with an assessment of what ultimately, let us pick up 200 public projects. See what was L1 or H1 as the case may be. and do an analysis as to how much was the ultimate amount paid by the government. No, by the government. I mean, of course, public money is an element which is built into that. But how much was the money which was ultimately paid by you and me through the government for that project? So that's an assessment which could be the basis. And of course, you can't do away with L1 because it has contours which, unmanageable, corruption, etc., etc. But that is something which can be very, very helpful as a case study, and then taking it through a formal body and then coming out with the report.
Sure.
I would just add one nuance
your,
to it.
Your thoughts, because you are listening
May I just add to that, and then of course, the nuance that I would like to add is don't just do what the government paid. Please consider what the citizen ended up paying. Because what the citizen did not get, because the government sat on a decision. Unfortunately, what we forget is India, the time value of money, now a part of legislation and IBC, is completely ignored. I mean, Mahadev Selko, 1995, big lament by Supreme Court. One house in expansion of the road in Pune delayed the project by 24 years. Can you imagine what the capital cost was? Who was paying for it? Nobody.
So I don't know if anybody has any other thoughts.
So, Vyapak, I may want to just bring one more suggestion since we are on this. So lenders evaluate every project that happens before it is bid out. So in European and in Latin America, what we are seeing in construction and infrastructure development projects is that when you bid, you have to submit with your bid a bank's evaluation of the financial case, the banking case. And that kind of gives so much credibility to what the bids are, because obviously on an L1 bidding scenario, people run towards bringing the value down. But if you were to kind of get the lenders to play the role of evaluation of the bid when it is filed, right? Just take the big example of, this Ahmedabad road project with GMR bid. The price point of GMR per kilometer was 120 rupees lower than the other bidder. In the end, Kishangarh, Ahmedabad, GMR actually gave back. Sure. Because it couldn't be done at those numbers.
At that level.
L&T was at the other extreme, and KNR, which was supposed to be one of the better bidders, was on the opposite side. So I think one suggestion which maybe can be adopted by the government is get the lenders to do the basic work and evaluate bids.
Sure. Any other questions or comments from the? Yeah, please. I think you guys also came up with a very strong report, at least on the Indian construction industry.
Thanks for that. It's really interesting talk, slightly depressing. I was just going to say that Anand was saying about the NEC contract, and we've had...
Can you also introduce for the rest of the audience?
My name's David Goodman from Kroll. I've been doing construction disputes for about 20 years. NEC is a great contract. Every government contract in the UK insists that it has to be under the NEC. But the power of it is you need both parties to absolutely buy into it. So you need the government to sign up to use the NEC. It will never work if it's a one-sided contract, like most contracts. But it really is. It's very admin heavy. And it's all about keeping constant records up to date so that everyone knows exactly where you stand. And I just wondered whether you thought, is there a do you think the government would be willing to take on that kind of contract? It feels like they're not. They don't feel that they would.
I think that's where we'll have to push. Government is very happy where they are because people are still bidding and taking contracts with all the risk there is. So an informed opinion coming from the industry bodies, even if pulling out all the jurisprudence that's come to show the risk from a lender's point of view, from an investor's point of view. And by the way, I mean, while I have great concern about lenders, but lenders are often on the boards of those companies, but sit quietly and go to Goa for the beaches, for shoots, and take the checks. It's their fiduciary duty to come up on it on their own. They don't need to be invited to a party for it. There's a problem there.
Also, in 2016, there was a committee cabinet committee on economic affairs, which had actually suggested that, FIDIC should become the norm, but it has never seen the light of the day. I mean, it's biting the dust even now. So you're right, David. I think, is the government actually willing to push the button and say that, this is how the contracting ought to happen? Most times, it is obviously to the advantage of the government not to do anything, and it's to the advantage of the government companies not to do anything because they don't want to pay. I mean, that's the bottom line. And, in every contract, that is what it comes down to. How much are you willing to pay for, what you are getting? And largely what you'll find is that these contracts are known as lump sum contracts, though actually they are not lump sum contracts. The very fact that there is a change order and a variation which is inbuilt into the contract does mean that there is, and over and above that is required to be paid if there is any variation that the government would ask for. In fact, I happened to just finish a matter where the argument which was, bandied about was that, I asked for a variation and there is but there is also a clause which says that I will not give you anything over and above. So there was no profit element that you would get. On the other hand, if the government was to get anything, there was a 15% markup which was built in. So you can imagine, the kind of inequities that we are dealing with over here.
Sure. And I would agree that, NEC is a very, very good template because it has a very good subcontract network contracts which are available, and you can, easily adopt it, and it can work across sectors, especially the main contract and the subcontracts. They work.
But the bidders and the industry has to come back and force the government to.
And I think it's clause 10 of the NEC that says mutual trust and understanding.
Any last words, Ruchika? Because I think we are all, talking about the problems, but I think obviously we are talking because the industry is going through this. So from a lens of the industry, I think you would possibly have seen what are the cascading effects of what we are discussing.
One of the points which I wanted to point out was that we were talking about increased cost and these matters where litigations are there. I think we are also seeing a lot of public interest litigations being filed, and and some of them are really frivolous. So to give an example, in GMR, when we were doing the Goa April project, there was some petition filed in the Green Tribunal, and there was a stay given, and ultimately, when we reached the Supreme Court, it was dismissed. But during this whole process, almost 2 years were lost, and the matter was just dismissed with very, no cost at all. So in cases where even though public comes up with such litigations, I think there has to be exemplary cost by the courts, to at least desist the people from filing such frivolous petitions, because of which the matters are delayed and ultimately the construction, affects.
Yeah, thank you. At least our watch says time's up just now. So I think we are coming to the close of our session. Post this, I think there is a closing ceremony of the whole ADR week. We are having a honorable justice from the Supreme Court, and if I'm not wrong, Tushar Mehta, Solicitor General, is going to be here. But so hang on for a few minutes. But let me, in the meantime, thank the panel. Unless they have any final words, I think thanks a lot for giving both the legal and a general perspective, but more importantly, their experience on some of the real-time projects that have gone through the problems. And in spite and despite of all that, I think we do have solutions. I think so many of them came up from the both sides, from the dais and from the participants. But so I think why we have a solution, it's a question of how do we execute and go forward. So with that hope and silver lining, may I request a round of applause for our panel, and more importantly, a round of applause for the participants to hang on. It's 96 for 2, so hopefully the third wicket will go before they reach 100. That's the wish we'll ask Amit to make before he gets up.
So I must admit, in between I did check. Rizwan was almost out on one delivery. You checked as well, Amit.
So thank you, everyone. I think just hang on for a minute. I don't know if Madhukeshwar and Niti are, the guest is here for the closing ceremony. Maybe Charlie, if you can check. Anyway, thank you.